The courtroom was packed, not with jurors. This wasn't a criminal trial, but with journalists, activists, concerned citizens, and a few silently fuming officials who'd come expecting a routine hearing and were about to witness anything but. At the center of it all stood Karoline Leavitt, former White House staffer, rising conservative firebrand, and the subject of a federal civil enforcement hearing over her supposed violation of political boundaries during a public town hall event streamed online. Her crime? Quoting the US Constitution too forcefully, yes. That was the charge. The judge, Her Honor Cecilia Wexley, was known across the Beltway for her cold demeanor and progressive interpretations of constitutional law, interpretations that critics called invention by omission. Karoline entered the courtroom not in a power suit but in a black dress with one thing in her hand, a weathered, dog-eared pocket Constitution. She didn't wave it. She didn't use it as a prop. She just placed it softly on the defense table beside her. The moment she did, Judge Wexley chuckled, a slow, smug, mic'd-up kind of laugh. "Leavitt," the judge said, looking over her glasses, "I do hope you've brought more than a thrift store trinket and a copy of Elementary Civics. This is a federal court." Karoline didn't smile. She simply replied, "This is a federal court, Your Honor. That's why I brought the only federal document that matters." A few people in the gallery murmured. The judge raised an eyebrow. "This hearing is about whether your words constituted a breach of the Hatch Act," the judge said. "Not whether you enjoyed an after-school reading of American folklore." Karoline slowly opened the Constitution. "No, Your Honor. It's about whether you believe the First Amendment still applies to those you disagree with." Boom. The room tensed. The judge's face hardened. "You will not lecture this court on constitutional law." Karoline didn't flinch. "Then I won't lecture. I'll quote." She turned to page 5. Clear, calm. "Congress shall make no law, abridging the freedom of speech." She looked back up. "And if this courtroom is going to pretend that quoting that sentence in a town hall is a crime, then the people watching outside this courthouse are going to have a lot of questions." Outside, they already did. Across live streams, social threads, and cable news chyrons, a new headline emerged. Karoline brings Constitution to court and brings the fire with it. Judge Cecilia Wexley adjusted her glasses again, tapping her gavel not to restore order, but to reassert dominance. The courtroom had gone too quiet. The kind of quiet that says someone just flipped the script. "I'll remind you again, Miss Leavitt," the judge said, her voice clipped. "This is not a rally. It is a legal hearing concerning potential misuse of influence under federal law." Karoline nodded. Understood. Then she flipped to the next page of her Constitution. Page 2. The 10th Amendment. "The powers not delegated to the United States by the Constitution are reserved to the states respectively, or to the people." She placed her finger under the words and looked directly at the bench. "Your Honor, with respect, this hearing is pretending that my speech in a town hall violated federal boundaries. But I was in New Hampshire, speaking to my own constituents. No government department was involved, no federal funds, no title, just words." The judge stiffened. "And those words were delivered during an appearance where you were introduced as a former White House official." Karoline leaned in. "I was introduced by someone else. I corrected them. I didn't campaign. I didn't solicit. I answered a question about the Constitution by reading from it. If that's a Hatch Act violation." She paused, her tone sharpening. "Then every founding father would be a felon in this courtroom today." A gasp echoed in the back. Even the stenographer blinked. Judge Wexley narrowed her eyes. "You think you're clever?" Karoline smiled, just barely. "No, ma'am, I just think the Constitution is clearer than your politics." Boom. A few hands rose to cover mouths in the gallery. Reporters scribbled harder. And outside, the live stream numbers were climbing fast. On social media, clips of Karoline reading the First and 10th Amendments were already trending. Hat pocket constitute Leavitt versus the bench, federal court or political theatre. Then Karoline dropped her next card. "And for the record, Your Honor, you have ruled on free speech before." The judge froze. Karoline pulled out a printed court opinion, Wexley v. Civic Union, 2019, and read the closing paragraph aloud. "The court must err on the side of speech, particularly when the message is political in nature and not financially incentivized." Karoline looked up. Your own words, your ruling. Are you prepared to reverse yourself?" The judge didn't answer, but her silence said everything. Judge Wexley leaned forward now, her tone sharpening like a knife slipping from ceremony into strategy. "Miss Leavitt, this hearing is not a debate on my past rulings," she snapped. "It is an examination of your actions, and whether they crossed a line defined by federal law." Karoline didn't flinch, but the shift was clear. The judge had just made it personal. "Understood," Karoline said. "But if we're going to talk about lines, let's make sure we're using the same ruler." The gallery rustled with energy. Cameras weren't allowed, but the eyes of America were already watching through 1,000 live blogs, threads, and recap reels. The judge continued. "You quoted the Constitution in a public forum while being introduced as a political figure. The issue here isn't your right to speak. It's that your words may have improperly influenced voters during an active election cycle." Karoline folded her hands, calm, focused. "Then I guess the new legal standard is truth is only allowed when it's convenient." That stopped the judge cold, just long enough for Karoline to slide a manila folder across the table. "This," she said, "is a list of 14 federally appointed officials who appeared at public universities over the last 6 months to speak on climate policy, education, and gun reform, all during active legislative sessions." The judge said nothing. Karoline continued. "Not one of them was investigated, not one charged, not one dragged into a federal courtroom to defend their right to speak." She paused, then looked straight at Judge Wexley. "So tell me, is this about my words or the fact that you don't like who's saying them?" The room went still. That quote would go viral before Karoline left the courthouse. The judge slammed the gavel. Enough. But Karoline wasn't done. "I respect this court," she said, raising the Constitution, "but I will not apologize for quoting this." The judge narrowed her eyes. "Then you should prepare yourself, Miss Leavitt, because quoting it doesn't exempt you from being questioned." Karoline looked up, calm as stone. "I'm not afraid of questions, but this courtroom better be ready for answers." Another thunderbolt. Twitter X exploded. "Better be ready for answers. Karoline unleashed. You don't like who's saying it." The judge stared at her, suddenly realizing she wasn't just dealing with a former staffer. She was facing down someone who had turned the Constitution from paper into armor and wasn't backing down. Just as the tension in the courtroom reached a slow-boil silence, the federal prosecutor cleared his throat and stood. It was Assistant U.S. Attorney Leonard Grimm, known for long monologues and longer indictments. He wasn't flashy, but he was loyal to process, which meant this was about to get technical. "Your Honor," he began, "if I may, Miss Leavitt's citation of the Constitution is, of course, not on trial. However, we believe her comments, delivered at a politically sensitive time under the guise of neutrality, had the clear effect of influencing a local election, violating the spirit and language of the Hatch Act." Karoline raised an eyebrow. "The spirit of the Hatch Act?" "Yes," Grimm nodded. "The intent of the statute matters as much as the letter." Karoline leaned in, voice firm. "Then by that logic, I can be convicted based on how you felt about what I said, not what I actually said." That stopped Grimm in his tracks. She stood up, holding the Constitution in one hand and the manila folder of comparable violations in the other. "You want to know what influences voters?" she said. "Selective enforcement, biased targeting, dragging political opponents into courtrooms while allies of the establishment give TED Talks under federal titles without a whisper from DOJ." Gasps now. She turned to the gallery. "In the last 12 months, 6 officials spoke at public universities in swing states. 4 discussed pending policy. 2 criticized sitting members of Congress on the taxpayer's dime." She snapped the folder shut. "Not one investigation, not one headline, not one hearing." She looked back at Grimm. "You call this equal justice?" He said nothing. She turned to the judge. "You call this impartial law?" The judge, tight-lipped, said only, "The department is within its authority to bring these concerns." Karoline didn't blink. "So when I read the First Amendment aloud in a town hall, it's a federal case. But when a Secretary of Education calls parents extremists in a public school auditorium, it's protected commentary." Silence. The courtroom was no longer a courtroom, it was an audience, and Karoline was no longer on defense. She was doing what no one expected, putting the entire system on trial. The courtroom was sizzling with tension. Judge Wexley slammed her gavel. "We will recess for 20 minutes, she said sharply. "Counsel will remain available for sidebar discussion. The gallery is dismissed." The bailiff moved fast. The judge moved faster, disappearing into her chambers like a retreating general. Karoline didn't move. She stood still, surrounded by silence, until the door clicked shut behind the judge. Then she turned to her aide and whispered one word: livestream. The moment the signal went up, a backup phone, previously on airplane mode, powered off per court protocol, lit up and began broadcasting. Within 5 minutes, over 200,000 people were watching. And it wasn't from a fancy studio. It was Karoline, standing just outside the courthouse steps. No lighting, no makeup, just clarity. "I've just stepped out of a federal hearing where I'm being questioned for quoting the Constitution. Not summarizing it, not editorializing it, reading it. I presented evidence showing multiple federally connected speakers have done far more under official titles with no investigation. This isn't about fairness. It's about silencing a voice they don't control." She held up the same pocket Constitution. "And if quoting this document now makes you a defendant in court, then what are we even defending?" The crowd outside, which had grown during the hearing, erupted into cheers. People lifted mini-constitutions in the air like rally flags. "Karoline, don't back down. Read it again. We got your back." Inside the courthouse, aides scrambled. Reporters in the gallery live-tweeted the scene playing out on the courthouse steps. Breaking: Karoline Leavitt live streams during court recess. Viewership exploding. She's quoting the Bill of Rights again. Crowd growing, chant starting, "Read it loud." The judge's clerk rushed into chambers with a phone. "Your Honor, it's going viral. 2 million views in under 15 minutes. Judge Wexley didn't respond. Because what she feared most was already happening. The courtroom she controlled was no longer the one that mattered. Karoline wasn't just winning the hearing, she was reclaiming the conversation. When Judge Wexley returned to the bench, she didn't carry a folder. She didn't bring notes. She brought one thing: a warning. "Miss Leavitt," the judge said coldly, "you are advised that public commentary about this ongoing hearing may be considered a breach of decorum and, depending on content, a form of contempt. You are hereby instructed to cease live commentary on pending judicial matters while under review." Karoline didn't blink. "Are you threatening me with contempt?" she asked, "for speaking publicly about a hearing that already targets me for speaking publicly?" The judge leaned forward, her tone razor-sharp. "I'm warning you that the authority of this court extends beyond these walls, and your recent conduct flirts with undermining the sanctity of this process." Karoline didn't raise her voice. "The sanctity of this process ended when the court decided quoting the Constitution might be punishable." Boom. A pulse hit the room. The court reporter looked up. Grimm scribbled frantically. 2 members of the press had to muffle gasps. And outside? Karoline's live stream had already been clipped, transcribed, reposted. 12 million views. Contempt of truth. Karoline goes live. Read it loud. Back in court, Judge Wexley tried to redirect. "This hearing is about influence and intent, Miss Leavitt, not constitutional theatre." Karoline stood, holding her pocket Constitution in one hand and a new document in the other, a verified internal memo from a federal agency that showed prior coordination of narrative framing for federal officials at speaking events. "I know what this is really about," she said. She held the memo up to the court. "You're not punishing me for breaking the law. You're punishing me for refusing to play the script." Another shockwave. The memo cited strategy notes about which phrases federal speakers should avoid and the ones they were encouraged to use. Words like equity were in. Founding principles, advised against. Karoline looked the judge dead in the eye. "That's not guidance. That's state-approved vocabulary, and I won't be censored into a soundbite." A quiet buzz grew behind her. Even court staff were shaken. Because it was no longer just a bold defense. It was an indictment of the process itself. Judge Wexley was rattled, not shaken in the hands, not unhinged in her speech, but subtly, visibly rattled in the way that only someone who thought they were directing the play can be when the spotlight suddenly shifts away from them. Karoline didn't sit down. Instead, she raised a hand calmly and said, "Your Honor, with your permission, I'd like to call a witness." The judge scoffed. This is a review hearing, Miss Leavitt, not a trial. Witnesses are not. He's already been cleared for security and is present in the building, Karoline said. And he's not here to testify about me. He's here to testify about the culture that created this prosecution. The judge blinked. Then, reluctantly, who? Karoline turned to the rear doors of the courtroom. They call him the ghost in the halls, she said. You might know him as the former deputy counsel for the Office of Special Counsel. The gallery erupted in murmurs. The doors opened, and in walked Miles Franklin, a name not known to the general public, but instantly recognized by those inside the Beltway. A man who helped design the guardrails for civil service ethics law, and, quietly, walked away when those guardrails started turning into political weapons. The judge's jaw locked. Karoline gestured to the open seat. Mr. Franklin has submitted a sworn statement, she said, but I'd prefer this courtroom hear it directly. Miles sat down, calm, careful, precise. Your Honor, he began, I'm here because I've watched what was once a shield, the Hatch Act, turned into a sword. The room went silent. In the last 3 years, there has been an unspoken policy shift inside several agencies, he said. The idea was simple. If someone's words make us uncomfortable politically, find a technicality. He paused. That's not enforcement, that's weaponization. He looked at Karoline, then at the judge. I didn't come here to defend Miss Leavitt's politics. I came because this court is playing a dangerous game, pretending that context doesn't matter, and that quoting the Constitution equals campaigning. The judge tried to interrupt, but Miles kept speaking. Under the current internal guidance being quietly passed among ethics officers, had Dr. Martin Luther King Jr. read from the Constitution at a church event in 2024, he'd be under review for a Hatch Act violation. A thunderclap of realization rolled through the room, and online, Miles Franklin became a trending name within minutes. Whistle witness, he said what we knew Hatch Act exposed. Karoline folded her hands and looked at the judge. You thought this hearing was about my career. I'm here to talk about yours. The judge stared at her. No laughter, no smugness, just silence, because everything was shifting, and control was gone. The courtroom wasn't just tense now, it was alive, buzzing, murmuring, pulsing with the kind of barely contained energy that can only come from one thing, truth hitting the bloodstream of a system designed to suppress it. Judge Wexley sat frozen. She had expected fire. She had even prepared for fury. What she didn't prepare for was Miles Franklin. The moment his statement was finished, the room burst into whispers. Reporters darted out to make live updates, and the courtroom clerk's phone, silent until now, started buzzing violently. Across Washington, D.C., chaos had begun. Because Franklin's testimony wasn't just opinion. It was indictment. A former top legal advisor blowing the whistle live under oath in a courtroom that had just tried to discipline a woman for quoting the Constitution. The DOJ didn't wait until the hearing ended. They couldn't. At 2:38 p.m., a rushed statement hit the press wire. The Department of Justice is aware of the comments made in today's federal review hearing involving Ms. Leavitt and is reviewing the procedural integrity of recent Hatch Act-related enforcement. No further comment at this time. Translation: panic. Twitter/Lex lit up. DOJ backpedals. Whistleblower confirms weaponization of speech rules. Karoline was right, and they know it. Outside, a crowd had gathered. Some held copies of the Constitution. Others held signs. Speak truth. Stand firm. We're all on trial now. Inside, Karoline stood, calm, measured, but the fire behind her eyes had never burned brighter. She turned to Judge Wexley, who still hadn't spoken. You can end this hearing now, Karoline said, or you can continue pretending it was ever about justice. The judge finally spoke, but her voice cracked just slightly. You've made your point, Karoline nodded. Good. Now let's make it theirs. She turned to the gallery. To every American watching this, you don't need a courtroom to be heard. You don't need a robe to be right, and you sure as hell don't need permission to quote your founding documents. That quote detonated. It hit TikTok, Instagram, X, news banners. You don't need a robe to be right. It was over, at least for the courtroom. But the real hearing had just begun, in the streets, on the feeds, and in the minds of a newly awakened public. Karoline didn't wait for a ruling. She didn't ask for a recess. She didn't even glance back. She simply closed her Constitution, nodded to Miles Franklin, and walked out of the courtroom like someone who had just completed a mission, not attended a hearing. The doors opened, and what waited outside? A sea. Thousands of people had gathered in front of the courthouse. They didn't come because they were invited. They came because they felt it. A shift, an unraveling, a rising. The crowd parted like water, cameras swarming her from all sides. But Karoline didn't speak immediately. She stepped onto a makeshift podium, nothing more than a few crates, and looked out over a crowd holding signs. The Constitution is not partisan. Truth isn't a campaign violation. We heard her. She raised her voice, not to shout, but so the silence could surrender to clarity. They brought me into that courtroom to make an example out of me, but we flipped the script and made an example out of them. Cheers. This was never about me. It was about whether quoting our most sacred text in public makes you a criminal in the eyes of power. And if that's the country we've become, then it's time we take it back. The crowd erupted. Live streams cracked 20 million. Podcasters called it the new Tea Party moment. Senators, yes, sitting ones, started reaching out within the hour. And back in D.C., the DOJ's second statement of the day dropped like a white flag. All pending Hatch Act investigations involving non-appointed officials are being paused for internal policy review. Translation? They surrendered. Karoline's phone rang off the hook. Newsrooms, networks, even opposition campaigns trying to welcome her back into the fold. She declined them all. Instead, she posted one sentence on her X feed. "I'm not going back to play by their rules, I'm writing new ones." That post, 28 million impressions in 6 hours. Because Karoline Leavitt didn't walk out of that courtroom alone. She walked out with the people. And when the people walk with you, the system can't stop you. 2 weeks later, the country was still talking. Karoline Leavitt's hearing had gone from a niche procedural battle to a nationwide flashpoint, not because she shouted, but because she quoted, not because she played the system, but because she unmasked it. Cable networks ran 24/7 recaps. College students began carrying pocket constitutions again, not as kitsch, but as defense. Churches, barbershops, high schools, and town halls started quoting her like she was a founding author herself. You don't need a robe to be right. I wasn't on trial, the process was. Read it loud. And then came the press conference. Not in D.C., not in New York. In Concord, New Hampshire, at a farmer's market surrounded by snow-dusted fields and folding chairs. Karoline stepped up to the mic. Reporters braced for it. A campaign announcement. Senate run, House seat, VP shortlist. But what she said instead shocked everyone. "I'm not announcing a campaign. I'm announcing a course." Confused murmurs. She smiled, held up her Constitution again, and continued. "Today I'm launching the American Speech Project. A platform to train, equip, and empower citizens, not candidates, to defend the Constitution in their communities." Gasps. This isn't about getting elected. It's about getting educated. We don't need more officials. We need more voices. She tapped the document gently. This only works if people read it. Loudly, publicly, proudly. The announcement hit like a meteor. Within hours, schools and civic groups were signing up. Donations poured in. Former adversaries even acknowledged, "We underestimated her. This wasn't a publicity stunt. It was a blueprint." Karoline's course went live within 48 hours, free, digital, and designed to arm every American with what they'd need the next time someone tried to silence them for quoting their own country's founding document. She didn't just survive a federal hearing. She didn't just go viral. She built a movement. And she proved that the Constitution isn't just a relic on a wall. It's a weapon when they try to rewrite the rules.